I will discuss the basics about the International Criminal Court, and I will tell you that the International Criminal Court is created because of some reasons, and the reasons have been that I have already discussed with you. The reasons have been the earlier experiences, like the experiences of Nuremberg and the Tokyo trials. Before that, you all now know that there was a sense of impunity, means people could commit any kind of crimes during armed conflicts, and they could escape from any kind of punishment if there was no law on it in their own country. So international law was not there. Whatever international law that I have been telling you about the existence of humanitarian law before the Second World War, that was dependent upon the state itself for its enforcement. And therefore, this Nuremberg and Tokyo trials, for the first time, it gave some sense of the development, some sense of the need to develop a different type of law which could punish even the individuals. And therefore, I told you that the Nuremberg and Tokyo started with this kind of concept of individual criminal responsibility. Thereafter, I told you about the experience of Yugoslavia trial. And Yugoslavia trial was a trial where you found that after the around 40 years of the Nuremberg and Tokyo trials, this Yugoslavia trial that also again gave another kind of lesson to the international community, that there is a need to establish some sense of institution by which these people who are very powerful people and who are at the helm of affairs in a country, they can commit such kind of heinous crimes. In such cases, these tribunals like former Yugoslavia tribunal, I have told you at length about it, that how in the former Yugoslavia, very many powerful people like Radovan Karadzic and Milosevic and Tadic, all these cases I have told you. So these were some of the examples that after the Nuremberg and Tokyo trials, again former Yugoslavia proved that these things are important. Apart from that, there were certain other experiences and lessons from these former Yugoslavia, Nuremberg and Tokyo trials, that there should not be a kind of hegemonic justice. Hegemonic justice means a victor's justice. Victor's justice means that the countries which win the war and thereafter they what they do, that they want to punish the perpetrators, and in such case what happens that in such case if the perpetrators are to be penalized, then it is, although it may be supposed there may be a sense of fairness, but then there may also be a sense of subjectivity and also a sense of hegemony amongst the different actors in the world. So Yugoslavia trial, because I told you Yugoslavia tribunal was established by Security Council, and Security Council, many countries believe that Security Council does not always act impartially. So this is also the lesson which was learned in the case of Rwanda trial. Although positive side of Rwanda trial was that this was again a trial which established at the international plane the importance of individual criminal responsibility. It also established at the international level the sense that individuals can be punished for violations of international humanitarian law. It also established at the international level that the punishment may not be always the capital punishment, but the punishment can also be in terms of no capital punishment, so maybe life imprisonment and likewise. But at the same time, these tribunals also established that these are all, like Rwanda Tribunal was ad hoc one, so it was not permanent. It was not so. At many places in the world, many people believed that okay, this is the tribunal which was meant for Rwanda only. In the example of former Yugoslavia, many other countries believed that okay, because this was Security Council created tribunal, and therefore this was only with respect to a particular country or a particular region of the world, and therefore they need not worry. So again, you know that it was a very limited sense of fear for international criminal law. And therefore what happened that because of these lessons and other lessons that were also to be learned, that suppose if you want to establish an institution in future which will be kind of a permanent international institution, then it should be also based upon the consent of the countries. So consent of the countries mean that it should be based upon some kind of treaties, and treaties must be opened for all the countries of the world. So whatever countries they will like to join that treaty, that country may recognize the jurisdiction of international criminal law over it. So these are some of the basic things that I wanted to make you understand, because just I will jump onto International Criminal Court, you will not understand what was the rhyme and reason to establish International Criminal Court. If I just come on to the International Criminal Court, International Criminal Court is the new institution, which is the institution of 21st century. And in this institution, what happens that this institution is not created by Security Council. This is not created by the victorious parties in any kind of armed conflict, but it is a tribunal which is created on the basis of a long work done at the level of United Nations, as well as by many non-political universities and institutions. I have discussed with you that the Nuremberg trial and Tokyo trial, it started into making of a draft code on offenses against humankind, and that was drafted by International Law Commission of International Law Commission of United Nations. So since that, and that was the job which was done in 1948 itself. Since 1948 itself, you see this ILC draft code. It should not be statute, but it is draft code of. So it was a draft code on. The offenses against mankind. You see. So from that draft code to the draft statute of 1994, which was finally developed, evolved by again International Law Commission. And International Law Commission is not the law commission of a country. Most of the students, they say that okay, maybe that some individual of United States might have created it, or some individuals of China or Russia might have created it. No. So it is International Law Commission is a diverse body which is very focused and which is apolitical and which is not biased. So that International Law Commission has drafted this statute, and then that was a model for the treaty, which was called later on Rome Statute. You see, so 1994 International Law Commission draft statute, and the 1996 Draft Code of Crimes Against the Peace and Security of Mankind, 1996, and thereafter, these were the basis of 1998 Rome Statute. So this is the Rome Statute, which is an example of treaty. It's called statute, like the Statute of International Court of Justice. These statutes are the basis of the functioning of these kind of courts. So like the Statute of International Court of Justice, which is the basis of the functioning of the International Court of Justice, Rome Statute is the basis of the functioning of the International Criminal Court. So in 1998, Rome Statute was opened for signature by any country of the world, whether they are the members of United Nations or whether they are not. So it is not a treaty which is only meant for United Nations member states. It is also meant for non-UN member states, although the non-member UN states number is very less and very few. So that was how you see that this treaty was opened for signature, and 60 countries were required to make this statute of International Criminal Court start working. So unless and until 60 countries will not sign it and ratify it, this court will not be started. So it took some time, and by 2002, late 2002, 60 countries had signed it. So and thereafter, the whole process to start this court was started. And since 2003, this International Criminal Court has been functioning at international level in The Hague, which is one of the capitals of the Netherlands. So in The Hague, International Criminal Court has been functioning since 2003. Now it is almost 17 years of its existence. International Criminal Court is doing a fantastic job to develop international criminal law and enforcing international humanitarian law, as well as the principles of the laws of armed conflict. Now, since 2003 up to 2020, if you look at the number of states which have accepted the jurisdiction of this court, are 123. So almost 60% of this whole countries of the world, they have accepted the jurisdiction of the International Criminal Court. So it's a good percentage. Most of the countries have accepted it. If you look region-wise, you see that from Africa, 33. So again, it is like more than 60%. Asia Pacific, again 19, very good. Eastern Europe, 18, it's again very good. Latin American and Caribbean, 28, very good. And Western Europe and others, it's the best, 25. The laggards are Asia Pacific and Eastern Europe. So from these, and also Africa. So these are the three regions of the world where some countries have also not signed the Rome Statute. Now, if I talk to you about the structure of International Criminal Court, the structure of International Criminal Court is that it has the office of the prosecutor, like some of you might in future may give the examination of the prosecution, what we call public prosecutors exam. So that kind of, there is no exam for that, prosecutor's office of International Criminal Court. But then the prosecutors are appointed by the Assembly of States Parties. So what is the meaning of Assembly of States Parties? Assembly of States Party is an assembly of all those states which have finally signed and ratified the Rome Statute. So all these countries, they will be finally appointing the prosecutor out of various names suggested by different states. So the prosecutor is appointed, and thereafter deputy prosecutors may also be appointed by the prosecutor out of the list given by the prosecutor, and then afterwards the nations may give their voting. Which nations? It will be again Assembly of States parties. And thereafter there is also a judicial division, which is consisting of 3 divisions, and those divisions are at the bottom is pre-trial division, in which a single judge may also be there, and maximum it may be composed of 3 judges. There will be a trial division where at least 3 judges benches will be constituted, where the trials would take place. And thereafter there would be appeals division, where whatever appeals are coming from the trial division judgments, those would be decided. So there is also appeal provision in this International Criminal Court system, and this appeals division is totally different division. So it is not that judges from the pre-trial or trial division will again sit in the appeals division. So appeals division is a separate division altogether, and it is constituted at least of 5 judges, because the ambit and the scope of appeals division is wider. They have to finally decide, because there is no appeal from the appeals division orders, judgments. Therefore, the appeals division have to be acting very cautiously and maturely and wisely. So how many judges are there in the International Criminal Court? There are 18 judges who are selected by Assembly of States parties, and they will be appointed as judges. So again, it is based upon the different regions of the world. There is also a division which is called a registry, which is non-judicial division, and where the cases are filed, whatever cases have to be filed, they will be filed in the registry, which is also located in The Hague. As far as the languages are concerned, you are all fortunate. You can be the prosecutor, but then it is very difficult for Indian citizen to become prosecutor in International Criminal Court right now, because India is not a party to the Rome Statute yet. Thereafter, I will move on to another thing which is about International Criminal Court, is that how the jurisdiction of International Criminal Court is invoked. So, because jurisdiction is very important part. Whenever you go to the court, the judges will look first of all at the fact that whether they have the jurisdiction over the matter which is filed in their court or not. So this jurisdiction, you must understand, if the matter that you have filed as an advocate or counsel, if you will not file it in the proper court, your application or your suit or your case will be outrightly thrown away by the judge. So what is the jurisdiction? It means that how the trigger mechanism of the court that can be pressed. So we have 3 trigger mechanisms according to the Rome Statute. The first is that the states parties, they can refer a matter to International Criminal Court. So suppose if a country A is a party to the Rome Statute, and if country A wants to refer any matter which it thinks that it will come under the jurisdiction of ICC, then state may write an application to International Criminal Court requesting that the matter should be dealt by International Criminal Court. So in that case, again, the procedure will start. So what will happen, that the pre-trial division may issue a warrant on the basis of investigation done by the prosecutor. So the states parties, the first trigger mechanism, what I will tell you is the states parties, they can start the trigger. According to Article 13 of the Rome Statute, I'll just show you the Rome Statute. You look at the Rome Statute. You see, this is the Rome Statute, and it says that the jurisdiction of the court according to Article 13 is that who can press the trigger mechanism of the International Criminal Court. You see this one? The court may exercise its jurisdiction when the situation is referred by a state party, is referred to the prosecutor by a state party. So this is Article 13, exercise of jurisdiction. And then it is elaborately dealt with in Article 14. A state party may refer to the prosecutor a situation in which one or more crimes that is committed. So you see that this is the first way in which a matter can be referred to the International Criminal Court. And then the second way in which the matter can be dealt with in the International Criminal Court is by way of referral by Security Council. Now, Security Council is not a part of International Criminal Court. Security Council is one of the principal organ of the United Nations. So you will wonder that how Security Council has been given a role in International Criminal Court. Now, this is very important to understand because there was a lot of negotiations which were going on when the Rome Statute was drafted, that what would be the role of United Nations. And then Security Council members, they were thinking that because they have been given the primary responsibility to maintain international peace and security, and therefore if they will not be given any kind of role in the International Criminal Court, then how can international peace and security at the international level be ensured? And therefore what happened that they were saying that they must be given a role in the jurisdiction of invoking the jurisdiction of International Criminal Court. So what happened finally that despite many oppositions to the role of Security Council in the International Criminal Court, Security Council was given the role to invoke the jurisdiction according to the Rome Statute. And if you look at Article 13, paragraph B, it says that the Security Council has a role. And if you look at this one, Article 13B, it says that a situation in which one or more of such crimes appear to have been committed is referred to the prosecutor by the Security Council acting under Chapter 7. So this is one of the limitations before even the Security Council, that Security Council will not decide to invoke the jurisdiction of International Criminal Court without acting under Chapter 7 of the UN Charter. It must act under the Chapter 7 of the UN Charter. And when it acts under Chapter 7 of the UN Charter, it decides, if you look at Article 39 of the UN Charter, you'll find that Security Council has to determine whether there is a threat to peace, breach of peace, or an act of aggression. And once there is a Security Council decision, and thereafter suppose Security Council has resolved that we must now refer this case to the International Criminal Court, in that case, it can do it now. So Article 13, paragraph B, and you might have heard about the cases which were referred by the Security Council, like Sudan's case, Darfur now. So Darfur's case was referred to the Security Council. Darfur's case was referred to the International Criminal Court by Security Council. Libya's case was referred by the Security Council. So this is very important thing to understand, because sometimes I have been asked with the question by the students that can it be possible that suppose if a country who is which is not a party to the Rome Statute, is it possible that such country can also be coming under the jurisdiction of International Criminal Court? The answer is, in such cases also the ICC can exercise its jurisdiction when the Security Council has requested the prosecutor of International Criminal Court to deal with a particular situation in a country. So suppose if country A, which is not a party to the Rome Statute, then the rulers of that country should not be under a misconception that they will never come under the threat of international criminal law. In such cases, there is a possibility that Security Council may act under Chapter 7, and thereafter, once it determines that the particular situation is a breach of peace, breach of international peace and security, or threat to international peace and security, or it is an act of aggression, then it may refer the matter to International Criminal Court, and in that case, International Criminal Court may exercise jurisdiction. So this is very important that Security Council has also been given the power to refer the matter to International Criminal Court. The third important trigger mechanism, which is also a little bit different from the common law countries like India, this is called proprio motu powers of the prosecutor to refer the matter to International Criminal Court. What does it mean? It means that the prosecutor of International Criminal Court may refer a matter to International Criminal Court on its own. And it's very different. You know, like we are in common law countries. India is a common law country. In India, if you become a public prosecutor, you will not have the power to directly bring a particular matter before a magistrate. So public prosecutor just assist the sessions court. But in civil law countries, this is a feature of common law country that I have been telling you, that public prosecutors or prosecutors, they have only the duty to bring the not to bring the matter, but they have the duty to assist the court in the case. But in the civil law countries, even the prosecutors have been given the power to independently bring the matter before the court. And now this has been also incorporated in the Rome Statute. And in the Rome Statute, what you will find that proprio motu powers have been granted to the prosecutor to bring a case. And Article 13, paragraph C, as well as Article 15, they deal with such kind of situations. And if I again show you the whole Article 13C, it says that the court may exercise its jurisdiction if the prosecutor has initiated an investigation in respect of such a crime in accordance with Article 15. So prosecutor must initiate an investigation. And thereafter, Article 15 gives more details. It says that prosecutor may initiate investigations proprio motu on the basis of information on crimes within the jurisdiction of the court. So if he receives information from any source, it is not always the information which is received by the prosecutor should not always be from the states in question, but the information may come from even non-governmental organizations. So, and therefore, International Criminal Court has been able to investigate a lot of issues and instances. And after receiving of information, what will happen that the prosecutor shall analyze the seriousness of the information received. And thereafter, he or she may seek additional information from the states or from the organs of UN or from intergovernmental organizations or from non-governmental organizations, or even from other reliable sources that he or she deems appropriate, and may receive written testimony or oral testimony at the seat of the court. And also it says that the prosecutor must conclude that there is a reasonable basis to proceed with an investigation. And then once the prosecutor has a reasonable basis to proceed with the investigation, what prosecutor will have to do? Prosecutor will have to submit to the pre-trial chamber a request for authorization of an investigation. So prosecutor will not directly investigate or start investigation, but it will have to first of all receive authorization from the PTC, and thereafter what will happen that the PTC will take representations from victims and will look at the materials which are collected by the prosecutor, and thereafter if the PTC, upon examination of the request and the supporting material, considers that there is a reasonable basis to proceed with an investigation and that the case appears to fall within the jurisdiction of the court, it shall authorize the commencement of the investigation, and thereafter only prosecutor will start investigation. So it is not the case that PTC will always accept the request of the prosecutor to authorize him or her. maybe that in some instance, PTC may refuse to authorize the prosecutor to investigate. And this is paragraph 5 of Article 15. It says that the refusal of PTC to authorize the investigation shall not preclude the presentation of a subsequent request by the prosecutor based on new facts or evidence regarding the same situation. So maybe that PTC may refuse in the first instance, but again, suppose if a new evidence comes up in the same case, prosecutor may again file a request for authorization by the PTC based upon the new evidences. So what I was telling you, the whole motto was to make you understand that the prosecutor has been also given proprio motu powers to invoke the jurisdiction of International Criminal Court, and that you must know about it. So after that, I will also move on to the next thing, which is the subject matter jurisdiction. And this subject matter jurisdiction, I will tell you that what are the subjects which International Criminal Court deals with? Means what are the subject jurisdiction heads? Now, International Criminal Court has 4 subject matter jurisdiction. 4. 1, 2, 3, 4. 4. First is genocide. Now, genocide is under the jurisdiction of International Criminal Court. The next is crimes against humanity, which is dealt with in Article 7. The third is war crimes. And the fourth is aggression. Now, these 4 types of crimes are covered under International Criminal Court. If you remember Nuremberg Trial, Nuremberg Tribunal, what did I tell you? It was International Military Tribunal in the case of Nuremberg. So IMT at Nuremberg, it did not have genocide in its statute, but it had crimes against humanity and war crimes. IMT-FE did not have genocide, but it had crimes against humanity and war crimes. Then former Yugoslavia trial, it had genocide also. Rwanda trial, it had genocide also. But this is the International Criminal Court. For the first time, it has not only genocide, not only crimes against humanity, not only war crimes, but also a new subject, which is aggression. Although this aggression has been implemented only since 2 years now, it is just going to finish the 2 years, but so implemented since July 2018. So these are the 4 important subject matter jurisdictions that you must know about. And today I will be stopping here, and I will be now taking your questions before because this is only for 40 minutes, 3-4 minutes I will take your questions. And next time when we meet, we will elaborate upon the subject matter jurisdiction a bit, and thereafter we will move on to some of the cases which are decided by International Criminal Court, and thereafter we will also take up the stand of India. Okay, so what I will suggest to you that now you can also ask questions. Yeah, so you can ask questions now. You can unmute yourself, and yeah, so you can unmute yourself. Okay, so just 1 second. Yeah, so you can unmute yourself, and then you can ask me questions. Yeah, Nandini. Yeah, Nandini, ask me. Yeah, do you have any question? Hello? Hello? Yeah, so do you have any questions?
No, sir.
All right. So thank you, and we will meet next